to let you know that our first presenter, Bianca Atlas, lives and works in New Zealand and has kindly recorded her presentation so she could be with us at this particular hour. But because she can't be with us in person, she's offered to answer any questions via email, and I'll put her email in the chat. But I'll give you a brief overview of the speakers. So Bianca received her LLM with honors in animal law from Lewis and Clark's Law School in 2020, before writing her final thesis on the welfare of farmed fish in New Zealand, Aotearoa. I'm sorry if I'm saying that incorrectly. She holds a BA, Bachelor of Laws, and a Bachelor of Arts from the University of Auckland, and is Master of Science from the University of Edinburgh. Our next speaker is Jim Karani, who's an attorney who advises on criminal, animal, and environmental law. He's a co-founder of Lawyers for Animal Protection in Africa. He works in the courts with policymakers and stakeholders to strengthen the legal protection of wildlife species and the habitats they live in. He's currently pursuing a PhD in criminal justice at the John Jay College, CUNY, with research interest in environmental criminology. And last but very much not least is Imogen Allen, who is not Edie Bowles, but who has stepped in at the last minute, which we are so grateful for, because Edie had an emergency type situation come up and she's not able to be with us today. So we're really grateful for Imogen to jump in with us. She's the Advocacy and Communications Officer at the Animal Law Foundation. She brings nearly 3 years experience in marketing and communications within the animal protection sector. Now working through the lens of animal protection law, she focuses on raising awareness of systemic issues affecting animals and strengthening public engagement with campaigns for change. So that's our wonderful panel. Thank you all for joining us. And without further ado, we will begin the recording of Bianca's presentation. And thank you, Anna, for helping with that.
Good afternoon. It's a great pleasure to be speaking at this webinar today alongside Edie and Jim. A huge thank you to Professors Kathy Hessler and Joan Schaffner for inviting me to speak. Today I'll be speaking about the Japanese whaling case as a case study to explore procedural and jurisdictional issues in cross-border animal law disputes. Whales move across jurisdictions and are regulated by multiple overlapping legal regimes. This makes them an ideal example of the challenges faced in cross-border animal protection. A core question that arises is, who regulates animal harm that crosses borders? This question frames the entire Japanese whaling case. When animal harm occurs internationally, the issue is not only one of legality, but also of authority, forum, and enforceability. Central to the case I'm discussing today is the International Convention for the Regulation of Whaling, or Whaling Convention. The preamble to the Whaling Convention includes, among its aims, the proper conservation of whale stocks and the orderly development of the whaling industry. It thus preserves the historical binary objectives of conserving whale stocks and preserving the whaling industry. The whaling regime under the Convention provides for 3 types of whaling: commercial, Aboriginal or Indigenous, and scientific. In 1982, the central body of the Whaling Convention, the International Whaling Commission, or IWC, introduced a complete ban on commercial whaling, known generally as the moratorium, or zero quotas. The moratorium was intended only to be temporary. It was anticipated that whale stocks, at least of some species, would recover sufficiently to allow a resumption of whaling. However, all attempts to find an acceptable basis for a properly controlled resumption of commercial whaling have so far failed, and the moratorium remains in effect. While the Convention established a global moratorium on commercial whaling, Article 8 allows states to issue their own scientific research permits, creating a loophole. One of the major weaknesses of the Convention is its very rudimentary international enforcement mechanism. The main responsibility for enforcement of the provisions of the Convention remains with the parties to the Convention. According to Article 9, Paragraph 1, each state party is responsible for investigating and prosecuting breaches of the Convention that are committed by persons under its own jurisdiction, using its own domestic legal system. This limits the role of international oversight largely to reporting, monitoring, and diplomatic pressure, rather than coercive enforcement. Over the past 80 years, the IWC has attempted to operate as a forum within which often irreconcilable conflicts of interest are resolved. The lack of common understanding and the acrimonious atmosphere between the members of the IWC over the decades has had a paralyzing effect on the functioning of the IWC and has led to international litigation, including the Japanese whaling dispute. One of the most contentious questions under the Whaling Convention has become Japanese scientific whaling. This led to the 2014 Whaling in the Antarctic case, which I'm referring to as the Japanese whaling case. Just a note on New Zealand being an intervening party. Under Article 63 of the International Court of Justice, or ICJ statute, a state that is party to the Whaling Convention can intervene in ICJ proceedings when the interpretation of the convention is in question. This allows the intervening state to submit written and oral statements on the legal issues at stake. As an intervener, New Zealand had the right to participate in oral proceedings and present legal arguments regarding the interpretation of the convention, but it could not independently expand the scope of the dispute or claim remedies beyond those sought by the principal parties, that is, Australia and Japan. In this case, both Australia and New Zealand alleged that the Japanese scientific whaling program, or the so-called JAPA 2, was in fact not for the purpose of scientific whaling. The ICJ agreed. In its judgment, the court reiterated its view that JAPA 2 appeared to involve activities that could broadly be characterized as part of scientific research, but that the evidence was insufficient to establish that the program's design and implementation were reasonable in relation to achieving its stated objectives. The ICJ concluded that the special permits granted by Japan for the killing, taking, and treating of whales in connection with JAPA 2 had not been for purposes of scientific research. This is the core holding of the case. Key here is that the court did not accept Japan's characterization of its own program at face value. Instead, the court evaluated the actual design, scale, and outputs of JAPA 2. This matters doctrinally because it limits the ability of states to rely on self-judging exemptions without evidentiary support. It also shows that international courts can, in principle, scrutinize animal use justifications, even if they do so through a state-centric lens. In other words, the case demonstrates a rare instance of substantive review rather than deference, narrowing the scope of self-judging treaty exemptions. However, the self-imposed limits of the court's reasoning are evident in the judgment. While the court scrutinized scientific justification, it explicitly declined to engage with questions of desirability, policy, or animal welfare. And this is critical. Suffering can be procedurally sidelined, even in cases involving large-scale killing of animals. This reinforces the structural invisibility of animal welfare in international adjudication, reinforcing the object-based status of animals in international law, as in most domestic laws. To be clear, animal suffering was treated as legally irrelevant through deliberate exclusion, not oversight. Ultimately, the ICJ ordered Japan to revoke any permits in relation to JAPA 2. The strength of the court's language and the clarity of the order is notable, but contrast this with what happened next. What happened in the wake of the ICJ ruling is crucial because it reveals the enforcement gap at the heart of international animal law. On paper, Japan complied with the ICJ ruling. They did terminate JAPA 2. But in practice, they simply withdrew from the IWC in 2018 and resumed commercial whaling in their own waters in 2019. The whales are still being killed. The difference is that now this is happening entirely outside international oversight. Japan's response illustrates how states can adapt strategically to adverse rulings, limiting the long-term protective impact for animals. This highlights both the strength of the remedy and, when read with subsequent events, its practical fragility. This gap is especially consequential in animal law, where harm is ongoing and irreversible. So this slide just synthesizes the key structural problems that this case serves to highlight. I've organized these into two categories: procedural barriers and jurisdictional limits. On the procedural side, we have the standing issue. Only states can bring claims in the ICJ. Animals, non-governmental organizations, and affected communities do not have standing. This means animals themselves have no legal voice, and their suffering is rendered legally invisible unless a state chooses to represent them indirectly. Even when the harm is to animals, the case must be brought by a state and must be framed as a dispute between states, not as a claim on behalf of the animals themselves. In this case, Australia brought the claim and New Zealand intervened, but the whales themselves, legally invisible, their suffering, their interests are represented only indirectly, if at all. This procedural limitation fundamentally shapes what arguments can be made, what evidence matters, and ultimately what remedies are available. So even in this landmark case, the suffering of the animals who should be central to the case is legally invisible. As is the case under most domestic animal laws, international law treats animals as objects, and so any protection afforded to them is generally incidental. And now on the jurisdictional side, treaties like the Whaling Convention rely entirely on voluntary compliance and state self-regulation. There is no independent enforcement body with real power. And so conservation goals depend on state consent, diplomacy, and political pressure. And critically, states can simply withdraw from treaties when they become inconvenient, as Japan did. These aren't just theoretical problems. They're the structural reasons why even successful litigation, like the ICJ ruling, can have such limited long-term impact for animals. So yes, tools such as international conventions and international courts can influence behaviour, but they're slow, politically constrained, and often ineffective at protecting animals directly. But despite its limitations, the Japanese whaling case may have had important normative effects and strengthened advocacy efforts. The ICJ's ruling made it clear that self-judging scientific exemptions are subject to meaningful judicial scrutiny, raising the evidentiary bar for states claiming research purposes. This shifted the burden of proof and made it significantly harder for nations to justify lethal whaling programs under Article 8 of the Convention. The case also galvanized global attention to whale protection, emboldening conservation organizations and providing them with legal ammunition in advocacy campaigns. Even though Japan ultimately withdrew from the IWC, I think the ruling reinforced international norms against commercial whaling and demonstrated that international courts can and will look beyond a state's characterization of its own conduct to examine actual evidence and intent. I'd just like to touch on a couple of comparative examples involving the regulation of whaling. While not direct responses to the Japanese whaling case, they represent ongoing and evolving regulatory strategies around the jurisdictional and procedural limitations that I've been discussing. Iceland actually resumed commercial whaling back in 2006, well before the Japanese whaling case. Like Japan, Iceland operates outside the IWC framework, under its own domestic authority. But what's particularly interesting is that in 2023, 9 years after the ICJ ruling, Iceland imposed a temporary suspension based explicitly on animal welfare concerns about killing methods. Whether this was influenced by the shifting normative landscape the ICJ case helped create is an open question, but it demonstrates that national jurisdiction can sometimes advance animal protection where international law has failed, though of course it depends entirely on domestic political will. Secondly, Finland offers a different model, territorial jurisdiction over trade. Finland isn't a whaling nation, but it did exercise control over its own ports and ban whale meat shipments through Finnish territory. This demonstrates how states can use trade restrictions as a form of indirect enforcement where they lack direct regulatory authority over the harmful activity itself. It's a kind of workaround to jurisdictional limits. Together, these examples illustrate that while international animal law remains fragmented and state-centric, there are multiple jurisdictional pathways emerging: domestic regulation, territorial control, and trade measures. The procedural significance is that states are finding creative ways to work within and around the structural limitations I've discussed, though these approaches remain piecemeal and dependent on political will rather than binding legal frameworks. The Japanese whaling case demonstrates both the promise and the fragility of international animal law. An important question for me is, what would justice look like if animal suffering mattered across borders? This is a central challenge for the future of animal law and international legal reform. This brings me to the end of my presentation. Thank you very much for your time and attention. And again, many thanks to Professor Kathy Hessler and Professor Joan Schaffner for the opportunity to be a part of this webinar.
That was wonderful. And so now we're going to shift from Bianca's presentation to Jim's. Thank you, Jim.
Thank you so much, Kathy. Let me set up the slideshow. If you can see it now. Thank you so much, Kathy, and the rest of the George Washington University team for having me. When it came to the topic itself, I was first of all inspired by the different, I will say, insights from different parts of the world. And then, of course, the one thing that I've noticed, even by listening to Bianca's presentation, is the similarity in problems. Whatever is happening in New Zealand for animals, it's probably happening in Africa for animals the same way. So for purposes of my discussion today, I chose to highlight some of the key issues happening in Africa, ideally in areas where either we have worked on or partner organizations have worked on, to just show you what this intersection between animal law and international disagreements actually looks like. What are the parts where we disagree on? And more importantly, how do we get ourselves out of it? So I chose to use wildlife protection as a key hook for this conversation, knowing that we have different types of non-human animals all over Africa with different challenges. So I chose to look into wildlife for now, knowing that other animals face similar issues. So for purposes of this presentation, I'll only focus on direct species conservation, wildlife trade, the trade in these species, and then of course the use of these species for food. I feel that these three issues will be able to bring out these critical wildlife issues. So first, by looking into the East Africa Court of Justice ruling on ANO's case. ANO is the African Network for Animal Welfare, which is a nonprofit in Kenya that sued the Tanzanian government in the East Africa Court of Justice. So regional courts have now emerged as amazing forums for pursuing what I will consider animal welfare and animal rights interventions. In this case, ANO was suing the Tanzanian government for setting up literally a highway that would have blocked the Masai Mara, Serengeti, corridor for wildlife migration. Now, all of us know about the seventh wonder of the world, and of course, the Serengeti migration is seen to be such an amazing resource. And then, of course, you can imagine Tanzania was in court arguing, hey, we should be allowed to use our natural resource the way we want to. And the court had to remind them that it doesn't matter what your development goals are. If it comes at the exploitation, or I'll say at the risk of destroying what are very valuable resources, we just can't allow you that. It has to be unconstitutional and against the regional convention that we use, which is the East Africa Community Protocol on Environment. Ideally saying that the protection of the environment pretty much was of more importance to East Africa than the highway. But then again, a critical look into this is how the court avoided looking into matters of, animal rights, whether animals should, have the freedom of movement. But the one thing we did notice is that the court was able to look at the collective impact of what this will be like. So, in as much as the court was not, impressed by the animal rights conversation, they remained open to looking at wildlife naturally as a resource. So we still have problems in trying to show the court that every individual wildlife is in its individual status, worthy of recognition and respect under the law. As you can see, it's a 2010 case. And in that time, courts have finally grown into agreeing that animals ideally do deserve protection from just purely on their rights to exist. So the African penguin case came up in South Africa, where the South African High Court ordered this 10-year fishing moratorium to stop the fishing of anchovies and sardines off the coast of South Africa. This will have directly impacted this migratory penguin, which was also critically endangered. And then the court went out of its way to say, hey, clearly this animal deserves way more protection than our export industry in sardines, which can always recover or move somewhere else. So the court was open and alive to the fact that, wildlife as individuals do deserve protection under law, and interpretation of environmental protection laws and animal rights and welfare laws was able to open a door to this. And for the very first time, I was really impressed by the court when it came to this, seeing the individual rights of this species as important, acknowledging and identifying that this species need their right to movement, their right to habitat, and then, of course, their right to food. Literally, penguins are competing with local fishermen on the sardine that was available. The more the fishermen were overfishing, the more the species were dying. So this was impressive from the court. However, when we go into wildlife trade issues, we find problems, especially in the enforcement of court decisions. And two things happen as a result. In 2019, the High Court in South Africa ruled that the export quotas and the exportation of lion bones to Asia was unconstitutional. Ideally, they were saying that the lack of consideration of animal welfare of the lions completely vitiated or made this trade unsustainable. That as a result, lion bone extraction was held to be, an illegal industry, completely killing what was a commercial enterprise in South Africa. But then what ended up happening is the enforcement of the court decision created this illegal market. In as much as we thought we were trying to fix things in the legal way, what happened is that the entire market just went underground. And we were shown this by the evidence in 2 months later at the Johannesburg airport. Some person was arrested with 342 kilograms of lion bones at the airport. So pretty much showing us that no matter how much we pursue these legal interventions, we also have to think about the illegal market, the illicit trade, to figure out how we can handle that. The other issue we faced around this area is the litigation from breeders, people who directly benefit from the exploitation of animals. They have proven to be the biggest stumbling block to the protection of species, across Africa, and it has completely made the management of wildlife in Africa pretty complex. The way nations are looking at wildlife is these are not individual species. Sometimes worthy of protection from a rights perspective, but worthy of protection from a resources perspective, that they are resources that can be exploited. So we're pushing litigation in this area, and a lot of NGOs in Africa are actually working on this to make sure that governments and courts start looking at this issue as an issue where animals by themselves are deserving protection purely from a rights base. Then the very last one is animals as food. Not only do we have ethical dilemmas, we have legal dilemmas. Now, I don't know whether any of you can remember the 2020 pandemic, which we can always trace to our animal consumption and the crossover for zoonotic diseases. In the last 5 years, I will say, most countries have gone out of their way to pass laws that protect people from animals, but we've done nothing to protect animals from people. And one of the biggest things we haven't done is we still haven't passed I will say progressive laws that stop, the consumption of wildlife meat. And I know how paternalistic it sounds for an East African like me to go to West Africa and tell them not to eat wildlife meat. But then again, globally, concepts like One Health, One Welfare have completely transformed our understanding of what needs to be done. And it's only a matter of time before we actually get to actual solutions. The other big issue we're facing is food labeling issues. Now, some of these are actively being litigated in court as we speak, with some of the big issues being Africa being this massive market of 54 countries, is also this very, very massive export market with animals going to the Middle East and Europe. And the question has always been, how can we, assure the consumer in Europe or the Middle East that they're actually eating something that was sustainably obtained or followed animal welfare standards? Standards just don't exist much in Africa, and that's a massive area where, for example, APA has found ways to bring in certification programs that for the very first time look into animal welfare as a direct factor of certification. Then, of course, one of the biggest food labeling issues is in the world, the global fish consumption and demand has pretty much tripled. And around 50% of all illegal fishing is traced to Africa. So people are dining on fish in expensive restaurants, not knowing that some of these fish has been taken from, West Africa, these tiny countries that can't protect themselves. So we are not sustainably fishing. We're literally stealing fish from most of these countries. Then, of course, using the most egregious of fishing practices. So how can we get out of this? This is my last slide. NGOs are suing for inaction. And inaction usually looks like this. Governments not going out of their way to ensure that their public are protected. And one of the key ways to do this, something that's become amazing and an alternative way of advocating for animals, is the right to a clean and healthy environment. Courts have largely interpreted that animal rights and animal welfare are a key allegory or are connected to environmental rights. This is huge, knowing that at least maybe a third of all constitutions in Africa and constitutions that will soon be written are acknowledging the right to a clean and healthy environment. So we're yet to see how courts are going to deal with this. Animal personhood has increased as a conservation conversation in Africa, but we are yet to see any countries that have gone out of their way beyond Egypt to, create personhood as a thing, as a complete concept that can, give animals standing for them to be better protected. And then lastly, the use of international law instruments, especially trade law instruments like CITES, which is a protocol to the General Agreement of Trade and Tariffs and Trade. And we know that with the increased complexity of international trade, using these international instruments is probably the only way to protect animals en masse, and obviously from exploitative trade practices. Then lastly, opportunities for legal professionals are abound. I want to only leave three things with you. And in this, one, environmental litigation that connects environmental protection and animal protection has pretty much emerged as a very elaborate arena of the protection of animals. If jurisdictions are now ready to see animals as being worthy of protection, then you can use this as an alternative by you can come in and use environmental litigation as a way of connecting animal welfare, animal rights, and the protection of the environment. And then, of course, personhood. Personhood is seen in Africa in different ways. Maybe it may not be seen from a legal perspective, but different cultures do consider animals to be persons. So this is not a new concept in Africa. It just needs to evolve into a legal concept. And then, of course, lastly, international law or whatever of it remains is an amazing avenue for the protection of animals, especially if we are talking of protection of migratory corridors, protection of international trade, and labeling. If we are to label products from South Africa and they're being traded out in Asia or the United States, labeling can completely change the dynamics of wildlife protection. Yeah, that's the very last of my presentation, and thank you for listening to me.
Thank you, Jim. That was wonderful. And now we'll switch over to Imogen.
Hi. Good afternoon, everyone. As Kathy already mentioned, Edie Bowles, the founder and director of the Animal Law Foundation, was unfortunately unable to make it today, so I'm stepping in to deliver her talk on how domestic law can impact animal welfare beyond a country's borders. I'm a relatively new member of the team, so if there are any questions at the end, please do email me. I'll drop it in the chat afterwards, and I will make sure we follow up properly. Today, I'll be speaking about how domestic law, laws made within one country, can shape how animals are treated elsewhere in the world. Animal welfare law is traditionally territorial. States or devolved authorities regulate what happens within their borders. But in a globalized economy, trade, supply chains, and regulatory alignment mean that domestic law increasingly shapes how animals are treated elsewhere. Post-Brexit UK law, EU internal market rules and national enforcement choices all demonstrate how domestic decisions can export welfare standards or welfare harm abroad. Take England's live export ban, a strong signal with extraterritorial limits. England, and Great Britain generally, now bans the export of live animals for slaughter and fattening under Animal Welfare Live Exports Act 2024. The aim is explicitly extraterritorial in effect to prevent animals suffering during long journeys outside the UK, often under weaker welfare regimes. There is, however, a loophole. The export ban does not apply to Northern Ireland, yet animals can still be exported from Great Britain to Northern Ireland. Further, under the Windsor framework, Northern Ireland remains aligned with key EU single market rules on goods, including animals. This allows continued live exports from Northern Ireland to the EU, which means calves exported from Northern Ireland may end up transported long distances and kept or slaughtered under welfare standards illegal in Great Britain. Domestic legislation can intend to reduce overseas suffering, but jurisdictional carve-outs and international frameworks can undermine that effect. Now, on to trade negotiations. Trade deals can be de facto animal welfare policy. Trade negotiations determine 1, what products can enter a market, 2, under what conditions, and 3, whether animal welfare can be used as a legitimate regulatory filter. In terms of the UK, trade agreements can open markets to products produced using practices illegal in the UK, for example, hormone-treated beef, sow stalls, lower transport or slaughter standards. This creates economic incentives for overseas producers to continue or expand lower welfare systems, and in turn can disincentivize domestic producers to improve their standards. Conversely, trade deals could require equivalence with UK welfare standards, which would improve the situation overseas and could be possible under World Trade Rules, as shown by the EU seal fur ban. But it isn't only formal trade agreements that shape animal welfare beyond national borders. Even domestic certification schemes can influence how animals are treated elsewhere in the world. Label Rouge is a French domestic quality scheme embedded in French law, yet it has driven production practices outside of France. Scottish salmon producers comply with Label Rouge standards to access the French market. This should, in theory, shape farming practices in Scotland. However, in this instance, there are concerns Scottish producers are not complying, which is currently being looked at by animal groups. And finally, court cases. Court cases abroad also influence animal welfare decisions in other countries. In recent years, Dutch courts have enforced EU rules prohibiting chickens being carried by their legs. This judgment created a persuasive argument this month in an English court making a similar case, with other countries also looking into legal action. This is because the same EU rules apply in other member states, which until recently included the UK. In conclusion, animal welfare standards are not purely domestic. Trade deals decide how animals are raised overseas. Frameworks like Windsor determine where domestic protections stop, and markets can impose domestic welfare standards. For England and the wider UK, the challenge is not just improving welfare at home, but how we engage with the standards in the rest of the world. Thank you.
Thank you so much, Imogen. Thank you all. These have been wonderful presentations, and I think highlight some of the challenges when we have a country that wants to use its domestic law positively to help animals, but is frustrated by an international scheme, and vice versa when the international treaty or regulation is stronger than the domestic law, and the tension between those. So we have, let me offer the first question from the audience, and this I think is primarily to you, Jim, asking, even without an animal rights law, were endangered or threatened species laws involved in the migration case? And did the Convention on Conservation of Migratory Species of Wild Animals come into play?
Some principle did come into play, but ideally, the thing they used a regional protocol, which is the East Africa Community Protocol on Environment, as the main document to say, hey, we as a region in East Africa have decided to run all our resources together, and as such, we can't allow you to do this one thing which we feel will damage this regional resource. So they did borrow on that. They could easily have gone beyond and borrowed from international conventions. They didn't even need to. From a legal standpoint, we have found that our laws, especially our national laws and our regional laws, are strong enough to be used and applied in court without having to go beyond that.
Thank you. That's really helpful. So another question. One of the difficulties appears to be distinctions in legal processes that apply to wild animals, animals living free, and animals who are captive and used for food production. So what, and this is for both of you, Imogen and Jim, what are you seeing as the distinctions in sort of the legal processes for those two, for animals in those two categories? Are there similarities? Are there differences?
Well, yeah, I think one of the greatest challenges is the lack of unified legal standards around this issue. And I usually have the same issue with whenever we see litigation from, say, New Zealand and Australia are the places where they've seriously litigated this. What's the difference between wild caught, what's the difference between farmed animals, and what's the difference between these legal standards of extraction? They have not been defined yet, especially in Africa. So when somebody tells you that something is cage free from Africa, be very cautious. Ask yourself, what does that even mean? If it's free range, if it's wild caught, that probably has no meaning whatsoever. So what we found is, in the alternative, we have amazing consumer protection laws. So it is one thing, if there are no standards, you can't come up with your own terms and then bring a product to market. You easily open up yourself to litigation risk. And I feel that's where large conglomerates, especially in the food industry, should be super, super careful that food labeling will be the key area where they will be caught out and they'll pay out a lot and lose a lot because there are no legal standards. And I usually feel like it is to their benefit that they will be the number one guys holding our hands, knocking down doors in government and asking for legal standards because we need them if they want to export products to the more lucrative markets like the EU, New Zealand, Australia, US markets. They must be ready to embrace legal standards. So without them, we don't have even the legal standards to start embracing the conversation. So that's what largely our problem is.
Thank you. Then following up on that really quickly, what are if you know, the opportunities for people in other countries to file claims within countries in South Africa, within any of the Great British jurisdictions, but maybe England in particular, for violations of consumer violations, perhaps, of labeling laws. So if there are welfare standards claims made, can someone from another country sue domestically, not in their own country?
If I may, I've noticed your question brings up an issue of standing and then of course jurisprudence. I think one of the biggest question is who has standing to actually bring these cases to court, and that's one of this literally the most litigated issue. It's the first thing we deal with when we get to court. I've noticed this that doing this cross-border litigation may not be possible if you don't have like a regional framework that grounds your standing. And that's why you see a Kenyan could sue Tanzania in the East Africa Court of Justice, but they literally couldn't do that in any other forum. So there is that too. Then of course jurisprudence. So strangely, because of us, all of us, almost all of us being former colonies of the British Empire, we all share the Commonwealth, and as a result, a lot of our jurisprudence is persuasive. It's never binding, but it is super persuasive. Ideally, in a court in Kenya, I could easily use a court ruling from South Africa to persuade a court or a judge in this case, and it works. Another thing that I've seen to be super, super powerful is just on top of the national interventions, there are, I would say, continental-wide interventions. We've seen this with the African Union framework. This is where literally the African Union is now trying to be like the EU, where they can do this, I would say, continental-wide regulations. And it's very, very promising, super interesting times for Africa, especially with the framework they set into place to ban and prohibit the trade in donkey skin and donkey hides in Africa. Literally, that framework is the only thing standing in between the Chinese juggernaut of exploitation and the remaining Africa donkey species. So, the minute the AU starts behaving like the EU, and we can't wait for them to establish a court that will allow us now to be able to sue anybody and everybody continental-wide. It's only just a matter of time.
That's really helpful. I'm sure it will be a little longer than we'd like it to be before it comes into play. And maybe in the meantime, this is where NGOs can come into play, because if they have members in the home country of the regulation, maybe that helps with the standing issue. It doesn't maybe help with the harm issue, but yeah, complicated. Another question is about enforcement. So even when we do have a law or regulation that seems to be benefiting or taking into account the harm to animals, we have these enforcement issues. And I think Bianca's presentation addressed sort of the unanticipated consequences, right, even of a win. But could both of you speak a little bit about your perspectives on the enforcement problem? You've raised a little bit, sort of foreshadowed a little bit of some of those problems, but can you talk a little bit more about enforcement issues?
Enforcement, there's a lot. I've seen a lot of discouraging things and also a lot of encouraging things. When it comes to enforcement, we have these four massive challenges. The first one is when the penalties are lesser than the enforcement action, it makes no sense from a financial position for enforcement to actually be serious. If the penalty is a slap on the wrist, then there's no point in wasting 4 or 5 times the resources to process this. So we need a lot of law reform in Africa to make sure that the penalties commensurate or at least match the proportionality of the damage you're claiming exists. Second, the resources. In as much as we like saying that we should be enforcing, that should also come from somewhere. It should be matched by actual budgets. So this affects the priorities of law enforcement agencies in that they will prioritize other areas as opposed to animal welfare. Then, of course, the very last one, the second last one is displacement. Whenever we go to Kenya and we work with law enforcement to make sure that, the exploitation of donkeys ends in Kenya, the Chinese industrialists just move next door. So displacement happens a lot. You stop crime in one country. I'm sorry, guys, I have a horrible cold. It goes to another country. So displacement has been a big issue. And we've seen this, the more we focus on Central Africa, they move to North Africa. So we are also moving with them. We become nomadic in our in our pursuit for enforcement. And then, of course, lastly, not only must we win in courts of law or work in courts of law, but we really must work in courts of public opinion. And if the public are not well informed on their role in enforcement, then we also lack this very powerful, capable guardian. You will notice that the public are the only enforcement we will ever need in any position if they only were alive to this. For example, I find with poaching, most communities know who are doing that. They even encourage it or facilitate it. They know who these guys are. So if we get into a situation where we are able to make them see the benefit of protecting or working with people to see the need to call law enforcement when they see animal abuse, or it will completely transform enforcement. It's not just about the formal law enforcement structure, it's also about the informal one, which is equally powerful. Yeah.
Thank you. Yeah, and that raises another question when we're talking about transnational border law, and that is how to address the cultural differences. And I think this builds on what you were just saying, Jim, right? So if the public uh, agrees with the value of protecting animal welfare, right, then it makes all of this a lot easier. But we're talking about either products moving from one country to another or animals themselves moving across borders in which there are different views, right, about the value of those animals and the importance of protecting them. So when you're doing law that either domestic law that has an extraterritorial effect or dealing with international regulations, how do you address these sometimes multiple cultural differences with respect to the views of animals?
Animal lawyers are now conflict of law experts. You just have to be. And I think it's recognizing that different jurisdictions look at these things differently. And unfortunately, I think I always blame colonization for this, is some of these very expansive areas of wildlife protection, while just cut into these tiny countries, when in reality they are better protected in a more uniform, or I would say in a more consolidated way. So we have those challenges. For example, Kenya and Tanzania, we protect our elephants, love them, prohibit, hunting. Next door, they shoot the elephants that cross over. So it's then Kenyans are gonna say, hey, we are losing our super tuskers to Tanzania, which has a very different consumptive utilization format to ours. So it's all about, I think, at some point, countries will have to either have consistent exploitation or consumptive use, or at some point they will have to find ways in which to coordinate this sustainable use. The science needs to be generated. As it stands, the science is just not there.
And are you finding, both of you in your work, that holding up positive examples from other countries, or when your country, the country you're working in, is doing something well, is helpful in moving laws and evolving regulations for other people, or do countries sort of resist some of that comparative analysis?
Super helpful. But you just have to be super careful not to insult cultural and I would say local sensitivities. The most obvious being if you're going to show up and tell them, hey, we are suing in court and saying you shouldn't be eating wildlife meat. You A proper sensitization and alternative movement needs to be in place to be able to push people to alternatives. And then, of course, a lot of consumer education. So I've found litigation and advocacy must go hand in hand. If you're telling them you're comparing them to Europe, you need to explain to them why Europe is better. Otherwise, you will look very paternalistic. If you're comparing one culture to another or one food to another, you must come with the right science and just water it down to a point where people can easily understand and connect with it so they can make the decision when they go to buy these products or use them.
Thank you. There's another question. Is there a resource where we can find agreements between and among nations which are not full scale, the Vienna Convention treaties?
Yeah, I think online there are so many options for this for conventions. Every single convention seems to have its sister agreements and sister conventions. If you, unfortunately, I, I think one major repository may not exist in the way it's been thought out to be. It's kind of like all over the place. You just have to dig on it a bit. If you want CITES, go look for you on the CITES framework and you might see it. If it's something United Nations, you might find it at the UNITA, I think United Nations training something.
Thank you. And we only have 1 minute left. So is there anything that either of you want to add to what you've already said? And if not, that's fine. That's fine. Yeah, you don't need to have any specific final thoughts. I want to thank you both, Imogen and Jim, and to Bianca, for your presentations. This has really been helpful, and I think it's really important as we take on the responsibility, right, to do our work, to be thinking about these extraterritorial types of impacts, as well as developing and forging alliances across countries, regions, and jurisdictions. So thank you very much for your work that furthers that. And we'll look forward to hopefully another series next year. Thank you so much to all of you.